Hello and welcome to the channel. The Supreme Court has reiterated its earlier ruling that the old Naira notes remain a legal tender. Recall that the Central Bank of Nigeria (CBN), through its governor Godwin Emefiele, after consultation with President Buhari, had extended the Naira swap deadline to the now past February 10. In a twist of events, some APC-led governors sued both the federal government and CBN to the highest court in the land, the Supreme Court, asking that the court bring a stop to the timeline put on the Naira swap. The Supreme Court, on its part, wasted no time in obliging and ordered the federal government and CBN against enforcing a deadline until its ruling on the matter, which was supposed to be yesterday, 15th February. Despite the ruling though by the apex court, the whole Naira notes since on the 10th has ceased to be a legal tender as businesses nationwide, petrol stations and even commercial banks have been rejecting it. The Supreme Court, which has had its ruling rejected by all and sundry, has again now insisted that the old notes is still a legal tender and that the executive arm of the government should comply with its directives. Well, we wait. Subscribe, like, share, and comment. Thank you. Old Naira notes remain legal tender, Supreme Court. The Supreme Court has said its February 8 order barring the federal government and its agencies from enforcing the February 10 deadline for the use of old 200 Naira, 500 Naira, and 1000 Naira notes still subsist. The court made the clarification on Wednesday following complaint by lawyer to Kaduna, Kogi, and Zamfara states Abdul Hakim Mustafa San that the federal government and its agencies have failed to comply with the order and have allegedly directed the rejection of the old notes. Mustafa said the plaintiff filed a notice of non-compliance with the order of the court made on February 8 and demanded that the court take action against the respondent to protect the dignity of the court. He added, "That order has been flouted by the government. We are talking of executive lawlessness here. We have filed an affidavit to that effect. We want the court to renew the order for parties to be properly guided." Justice John Okoro, who presided over a 7-member panel of the court, asked Mustafa to file a proper application to put forward his complaints and to enable the respondent respond appropriately. Justice Okoro said there was no need for a renewal of the court's order. He noted that since the order made by the court on February 8 was made pending the determination of the motion for injunctions filed by the plaintiff, the order still subsists since the motion was not yet heard. The court had, in the February 8 ruling, said, after a careful consideration of this ex parte application on the grounds in support of same, this court finds that there is real urgency for this court to intervene by the grant of this application. Accordingly, this application is hereby granted as prayed, that is to say, an order of interim injunction restraining the federal government of Nigeria, either by itself or acting through the Central Bank of Nigeria (CBN) and or the commercial banks, its agents, agencies, corporations, ministries, parastatals, organizations, or through any person or persons, natural and artificial, howsoever, from suspending or determining or ending on the 10th of February 2023, the time frame within which the now older versions of the 200 Naira, 500 Naira, and 1000 Naira denominations of the Naira may no longer be legal tender, pending the hearing and determination of the plaintiffs and applicants' motion or notice for interlocutory injunction. The Supreme Court has, however, fixed February 22 for hearing of the suit filed by Kaduna, Kogi, and Zamfara states challenging the propriety, the Naira swap policy of the federal government. The court chose the date after joining the Attorneys General of Katsina, Lagos, Ondo, Ogun, Ekiti, and Sokoto states as co-plaintiffs in the earlier suits filed by Kaduna, Kogi, and Zamfara states. Subscribe, like, share, comment, and please turn the notification bell on. Thank you. The court also joined the Attorneys General of Edo and Bayelsa states as co-respondents. Both states elected to side with the Attorney General of the Federation AGF, originally listed as the sole respondent. The court ordered that the suits filed separately by Nasarawa, Rivers, and Kano states on the same issue be consolidated with the one filed by Kaduna, Kogi, and Zamfara states. The court ordered parties to file all necessary documents before the hearing set for next Wednesday. Justice Okoro, before adjourning, told the lawyer to the AGF, Kanu Agabi, son, to advise his clients to ensure the availability of currency for the people. Tell your clients to let people have money. If they go to the ATM and the plaintiffs will come and withdraw the case, make money available to the poor masses. You should know that a hungry man is an angry man. I say no more, he said. Responding, Agabi said Nigerians were only blaming the government for their poverty. Many people don't have money. They blame it on the federal government, on the AGF. I don't have money too. Things have been bad for long. It is not today that the problem started, Agabi said. Governors Nasir El-Rufai and Yahaya Bello of Kaduna and Kogi states were in court to witness proceedings. Speaking after the court proceedings, Bello said the states were not at war with the federal government over its cashless policy, but are only concerned about its negative impact on the citizens who are now denied access to their funds. The Supreme Court of Nigeria was filled to capacity with a retinue of senior advocates of Nigeria, other lawyers, and the governors of Kaduna and Kogi states for the hearing of the substantive suits on the Naira swap policy of the Central Bank of Nigeria (CBN). At the last hearing, the court had temporarily banned the implementation of the February 10 deadline of the CBN from making the hold 200 Naira, 500 Naira, and 1,000 Naira notes legal tender. The Zamfara, Kogi, and Kaduna states had instituted a suit against the federal government and the CBN. Justice John Okoro, while proceeding, said the court should not lose sight of the case and its intention as it affects the suffering of Nigerians. Lagos State, through its Attorney General, Mayosore Onigbanjo, also applied, seeking to be joined in the suit. Bayelsa State, led by Damien Dodo, has also applied to be joined in the suit as a respondent. Similarly, Edo State applied to be joined as a respondent as well. That's the news, guys. Thanks for listening. Until next time, bye.